Good evening. Hope you are joining us live tonight. It is almost 7 o'clock and I've popped on to do this session a little bit earlier to make sure that we're all good to go and all the tech works before the witching hour. So welcome if you are joining us. It'd be lovely to have you on board. You can like and you can comment, and I will try and deal with the comments and the likes as we go along. Can't promise. Technically, doing three things at the same time, never straightforward, but let's go with it. I hope that the next 10 minutes or so are going to be useful, practical, user-friendly. I'm going to try not to talk in legal speak and lawyer speak because that's the worst thing in the world. Try and give you some pointers that I hope you'll be able to use in your business. I've done this once before. I did it for my very lovely friend Val Mattison and her group Above and Beyond the Kitchen Table. And then I ran in off the bus late, ran into a bar, grabbed a cup of tea and just went for it. And it sounded really good. And it was all, it was completely off pat, and it was quite a good session. This time I've thought about it too much, so you're going to have to bear with me if it doesn't quite reach the heady standards of the previous session. I'll try and work my way through it as best I can. So, not sure whether anyone is joining us, but you're welcome if you are. So tonight's 10 minutes, 15 minutes of wisdom, I hope, and certainly useful practical application for your business is 5 reasons why you need a client contract. Now, do you have a client contract? Do you call it a client contract? I don't know. You can call it a client contract, you can call it terms and conditions, you can call it a user agreement, the rules of engagement, what we expect from you. You can call it anything, but it's really important. If you don't have one, I can't stress more that it's really, really important that you get one done. You may have one that you've begged, borrowed and stolen from someone. You may have something that you have cobbled together off Google. That's fine, you know. But does it do all the things that you need it to do? Is it robust enough? Has it been tested? Do you need someone to have a look at it to see if it's still fit for purpose? Most important thing is A, it exists, B, it's in writing, C, it gets used properly. Now that using it properly is a whole different Facebook Live moment, but let's for the moment just concentrate on the content. I'm going to run through 5 things that I think you really need to check to make sure that you have them in your contract and why they're important. So number 1, in my view, the most important reason why you have a client contract is to set the expectations of both the parties. Most service and goods providers know their business quite well, and they might have been delivering it for some time, either in their current role or within other jobs that they've ever done. And there'll be a huge amount that you will assume about what you do, and knowledge that you'll assume that the other party will have about how it works and what you're going to do. Clients, similarly, who might be purchasing goods and services, they come at something with a set of expectations. They sort of think, well, that must be included and that can't be right. And so you can easily get into a situation where assumption meets assumption, they don't match, and that's where you end up in a dispute. So one of the primary purposes of having a client contract in writing is for you to set the expectations on both sides, because there'll be something that you'll need to do and there'll be something that your customer will need to do. And as long as you're clear about what those are and they come together, the expectations are matched, chances are that will reduce the risk of you having some sort of dispute about what you're providing and what you're doing. So absolutely key. Don't be scared about this. Don't worry about presenting someone with a contract. It doesn't need to be 97 pages of legal bumf that you think, God, I don't even know what the content is. I don't even know what it means. I'm giving it to someone to sign and they're going to ask me questions about it and I don't know what it is. It doesn't need to be something as complex and as difficult as that. You may get to a point in your business where you need something fuller, more lengthy, that does run to some pages, that does have extra terms in. You may get there. But if most small businesses either supplying business to business or business to consumer, you can have something that's relatively straightforward that deals with all the key points that will put you in so much better position than having either nothing at all, or alternatively having something not really fit for purpose. So, number one, setting the expectations. That's what you're going to do and what they're going to do. This is a two-way thing, okay? Two-way process. Number two, define those actions that are going to be expected of you. So that means, what are you going to do? Probably most important in many situations, when you are going to do it. To some extent, how you are going to do it, but don't confuse some of the mechanisms with that. You might not want to define every single step in a contract. Then it gets clunky and messy and long and unwieldy. But sometimes you need to define how you're going to do that. And then the other party has to define what they're going to pay and when they're going to pay it when they receive those goods and services. So those are the absolutely key points of a contract. Now, I am sure there'll be people watching this, and there may be some people considerably more qualified than me. So there's loads of other things like confidentiality and IP and blah, blah. And there are all sorts of additional terms that you may or may not need in your contract, depending on what you provide. But those are the key ones. What, when, how, payment. Okay. So, number three, the thorny question of deposits and cancellations. Now, lots of contracts will require some sort of deposit, and most contracts, but not all, will have some sort of provision about how you cancel them. Now, deposits can be in full, it can be in part, you can pay part now and part later and a bit more when this happens, and all sorts of potential scenarios. There is no standard, okay? So depending on what your service is, what your goods are, there's no standard position. You can define it however you want, as long as you define it. Put it in, that's the key. You need to set it out. So what are they going to pay? When are they going to pay it? What happens if they cancel or if they breach the contract? So is in that situation, is the deposit forfeited? Is the entirety of the deposit forfeited? Is just a bit of it forfeited? These are massively technical legal questions that lawyers could sit around charging you a very great deal of money to debate and never come to a necessarily conclusion. The question is relevant because you can try and limit all those fluffy vaguenesses in your contract if you set it out clearly. What you want someone to pay, when you need them to pay it by, what happens if they don't pay. Now, just because you've got something in your contract that entitles you to forfeit a deposit doesn't necessarily mean that you will in fact ask someone to forfeit the deposit. So let me give you an example. You are going to provide a service to someone on Saturday morning. On Friday night, they ring you and say, no, we don't want you to come anymore. You may say, okay, but you're not getting any of your deposit back. You haven't cancelled in time. Here's my contract. Clause 3A says that. Happy days. Scenario B, someone rings you at 7 o'clock on Friday night and says, oh my God, we've just come from the hospital. I've had a terrible time. Someone got run over. Someone's been diagnosed with some terrible condition. Someone's mother has just passed away. You know, serious family crisis of some other crisis. You may take a different view about what you do with the deposit in that situation. Now, your contract entitles you to recover that money from someone, but you can apply a bit of discretion. The most important thing is it gives you the choice. So if you have a situation where you think, well, that's reasonable, I think the proper thing to do in that situation is perhaps this. That's your choice. You can't make that choice if you don't have the option in the first place. So what happens with a deposit is hugely important, and it needs to be tied in with whatever you decide you want in terms of cancellations. And some people will have a very short cancellation period. You could have a graduated cancellation. I mean, there's all sorts of options, but have one and have it defined, have it written down. Number 4 in the top 5 reasons, limiting your liability. Now, here's where it can get a little bit technical, so bear with me. When I'm drafting contracts, I often say to clients, do you have any insurance? And they say, yes, we have insurance. We have £2 million worth of insurance, or we have £1 million of cover, and usually what they're describing is public liability insurance. Now, I am not an insurance broker, and I'm not giving advice about insurance because there are many people more qualified than me to do that. But in very simple terms, public liability is insurance cover for your business, so that if you do something within the course of your business, or your employers do something which causes an injury, an accident, a serious injury or death, that insurance kicks in and covers any claim against you for such damages. Okay. Now, in addition, you may have what I would call professional negligence cover. It's essentially insurance for when you cock it up. Now, that's not a legal expression, but when you do something wrong. So my business has professional negligence cover. Many professional services businesses will have that, and that will be to another limit, and that's a separate part of your insurance. Not everybody opts for it, not everyone needs it. I'm not giving advice about that. But essentially that professional negligence kicks in if you make a mess of something. You breach the contract, you act negligently in legal speak. Now, your terms and conditions can limit your liability for that second type of claim. So if someone claims against you for breach of contract or for your negligence, your terms can limit your exposure to the cover that you have on your insurance policy. Okay? It can limit it to a simple return of whatever money they paid for the services. I'll come back to that in a moment. What it cannot do is limit your liability under your public liability insurance. So you can't limit your liability for death or serious injury. There are 2 reasons for that. One is to do with consumer regulations and law, and a second one is to do with a piece of legislation, incredibly tedious but still very relevant, called the Unfair Contract Terms Act, which limits what you yourself can limit in your contract. Now, what that means in practical terms is that you can limit certain types of liability, but you cannot limit all liability. So even if you had a contract term that said, if I make a mess up, I'm liable for nothing, it wouldn't be enforceable. So don't just work on the basis, or if I just say I'm not liable for everything, I'll be safe, because that's not how it works, particularly if you're providing services to consumers, because they have quite a lot more rights than business-to-business arrangements. But terms and conditions can give limitations. They can exclude certain types of liability. They can limit certain levels of liability. I can't stress enough how important it is to take proper advice about this. Don't wing it, because if you get this wrong, your limits don't apply, and then you have open-ended liability, whatever your contract says. So hugely important to A, find out what your insurance cover is, B, find out what the limits are, C, apply the right limitations in your terms and conditions that are appropriate and are enforceable, and don't fall foul of the consumer regulations or the Delightful and Fair Contract Terms Act. And number 5 on the list of things that why you need a client contract, and for me, and I think for lots of people, this one's probably the most important. So we hopefully do jobs and we run businesses which we feel passionate about, that we love, that we enjoy. It might be quite artistic, it might be quite technical, it might be numbers based, it might be decorative. You could be running any sort of business. Whatever the goods or services that you're providing, you don't just do it because you love it. Generally speaking, we do it so that we get paid. We pay the mortgage, we pay the bill, we pay all the things that make the business work. All have to be paid. Employees, insurance, lawyers, dare I say it. So you need to make sure that your contract deals with what you're going to be paid. Probably, that's obvious. Perhaps more importantly, when you're going to be paid and what happens if you're not paid. Now, what you're paid and when you're paid pretty straightforward, so many days. But you might want to have provisions in your contract about being paid in advance. You might want to have provisions in your contract about staged payments. You might want to have the ability to say to someone, well, I don't need a payment now, I'll put off a payment until another time. In your control that fits your cash flow, you can do all of those things within a contract. The problem arises when someone doesn't pay. So again, does your contract deal with what happens in the event of non-payment? Are you allowed to charge interest? Can you charge extra interest? Can your terms dictate a level of interest that legislation, I'm not even going to attempt to explain what that might be today, what the legislation provides by default? Can you have increased? Can you have penalties? Yeah, you can, but you need to make sure that it's set down and correct. For people who are providing one-off services or one-off sets of goods, it's not such a problem, I suppose, because you can get paid before you deliver, and then you've been paid. That's okay. One of the problems arises where you've got someone who's providing services, perhaps on a monthly rolling programme to someone, and you start off, everything's fantastic. You do your bit, they do their bit. So you provide a service, they pay you. You provide some more services, they pay you. And this goes on, and then you might have a month where suddenly they don't pay you, or they don't pay you on time. Okay, and it's late. Then the next month they pay you, and we're back to normal. And then the next month they don't pay you at all, and you have to chase that. And then the next month they pay you a bit, and by that point you're a month and a half in arrear. At what point in that process are you entitled to down tools and go, I'm off, I've not been paid? Now, you would think that's a simple question. There must be a simple answer to that. Oh, you would be so wrong. Just because someone does not pay you does not entitle you to just drop everything and walk off the job. It might. It all depends on what's in the contract. Okay. So my advice would be, make sure that if you are one of those people who are providing ongoing services, you've got some provision which allows you to down tools in the event of a default on payment. Because if you don't, you could find yourself in a situation where your client is not paying you, but you still have continuing obligations to provide those goods and services. So, short recap. 5 reasons why you need a client contract. First of all, setting the expectations of all the parties. Hugely important. Number 2, define what you are doing, when you are doing it, and how you are going to be paid for it. Number 3, deal with the thorny questions of deposits and cancellations at the start. Don't get to a point where you go, oh, I don't think I can do this, or they decide, I don't really want this, what am I going to do? Number 4, limit your liability insofar as you can within the restrictions of consumer regulations, the Unfair Contract Terms Act, and the law generally. And number 5, and for me, as I said, probably the most important thing, ensure that when you've done a fantastic job for someone, you get paid for it, and you get paid on time, hopefully, and in full. So those are my top 5 reasons why you need a clear contract. As I said at the beginning, there are loads of reasons why. There are loads of other things that you can include, which we're not even going to attempt to cover in this. We might cover it in a later one, depending on what sort of feedback I have. But if you have any questions that you want to raise off the back of this video, or you think of something that you'd like to clarify that you've heard me talk about, you can always put a comment in the box below and I'll try and get back to you. I can't guarantee how fast that will be, but I'll be keeping an eye on the feed, and if you have questions that you'd like to ask, I'd be more than happy to try and answer them. And I can pretty much guarantee that if I can't answer them, I will know someone who can. So it's been lovely. I hope you've enjoyed it. I hope you learned something. I hope it's useful. Otherwise this is pointless. Thank you for watching, and please do comment, share, and otherwise engage with this post in the way that social media requires you to do. Like it, that will do for me. I'll be happy if you just put me a thumbs up, that'll do. Good to speak to you, and speak to you soon. Thank you.